to have this matter withdrawn and to terminate case 60 of 2019 to enable the areas highlighted to be covered efficiently and effectively, and to allow information that had not previously been available to be tendered. The best way, we believe, is to proceed through an inquest. My Lord, we cannot, in good faith, be able to proceed with this matter as it is, as it would not benefit the victims at this stage, nor the public interest. An inquest, we believe, will better serve the interests of all parties involved in this matter. That is all, my Lord.
Since we have indication that our defense is not opposed to this, I will hear the defense first. Mr. Mugo.
I'll start by stating what is now in the public domain regarding the misconduct of the former Director of Public Prosecutions.
So let us limit to this. Let us start with you do not oppose.
Thank you.
Yes.
I start by indicating.
Yes, so you do not oppose the position taken by the deputy.
Absolutely no. Not opposed. And I fully support it for the following reasons.
Yes.
It is now in the public domain that several or many cases were filed by the office of the DPP on a promise or an undertaking from the DCI, Judge Kinoti and his directorate, to avail evidence, or he had evidence and it would be availed. Charges were preferred in the hope and on the promise that the evidence would be availed. This is a classic case of such an incident. I will ask the court to go to page 1 of the proceedings. In this case, page 1. They are typed, so it's quite easy to refer to them. It starts on the 12th of September 2019 before the Honorable Justice Karim. And there is filed on that day an information on a charge of murder against the first. The information on the back page, flip side, indicates that the evidence was attached when in fact it was not. The record shows I personally raised that with the court, and the prosecutor, Ms. Moniki, very casually dismissed our concerns and said the statements would be supplied later. It took many months before drips and drabs of so-called evidence supplied, and finally a reference was made to the High Court or by the first accused, complaining that our rights had been violated insofar as investigations, prosecutions. I don't want to go into all of that, plenty of it there. The first ground was that in violation of the Constitution 2010, the BCI and of course the DPP had filed a case against us, a charge of murder for which investigations had not been done or completed. So, I don't want to deal too much into that detail, it's all there. But this then gave rise to no less than 6 letters addressed to the investigative and prosecuting authorities, calling fresh, independent, and unbiased investigation into the whole case, many areas including call data, as Ms. Bishui has mentioned. Our letters are dated, and I just want to give the date, 8th November 2019, 20th February 2020, 16th April 2020, 12th June 2020, 13th October 2022, and lately, the last one, 15th November 2022. All these letters, which are detailed, which are on file, are pleading for fresh investigations, unbiased investigations, and in particular, investigations that would have no involvement of the then Director of CID, Mr. George Kinoti, on grounds that he was conducting biased, skewed, and obsessive investigations against our client particularly, and subsequently against the judge of the Court of Appeal. None of these letters were replied to until, I would say, the response we have today. In the course of pursuing justice for our clients, there was even an attempt to have me charged on trumped-up charges as defense counsel. In addition, the records in these proceedings will show that Mr. Kinoti then pursued a course of tapping phones of the defense counsel and the judges handling this matter. So much so that, again, the record will show several judges, without giving reasons, declined to hear this case. It is so muddled up, so messed up, that the prosecuting authority can't move forward or backwards. They have now made an interesting revelation to us being the court and the defense counsel, that investigations were not done comprehensively. Call data was withheld, and statements of key witnesses not recorded. I see in the letter dated 29th November 2022, there is a reference to contradictions that have affected the proceedings of this court. They have referred to the affidavits of Mr. Gashomo, head of investigations at the DCI. Mr. Gashomo has stated on oath that in his last affidavit, the last one my colleague prosecutor referred to, that he signed a last page and gave it to others, to Mr. Kinoti, to go and fill in the other pages. And when he saw it, he was shocked because all of that stuff was false and not supported by the file that was in his possession. I expect in due course investigations will be carried out into the conduct of Mr. Kinoti in this regard, and even Mr. Gashomo. But I am dealing now only with what is before us. All of what anyone might consider evidence in the hands of the DCI is contaminated irredeemably. But yet, my Lord, a person has lost his life, the deceased in this case, and it is therefore in public interest, as I see it, having sat in the position of DPP in my previous life, that a public inquest be held. A public inquest will enable anyone who thinks they have evidence to offer to come forward. It will enable the suspects we consider were being victimized, including the first accused, to come forward and state whatever they wish to state. And it will enable an independent agency, independent of the DCI, and in particular Mr. George Kinoti, to come up with a recommendation as to whether or not there is sufficient evidence to pursue against any party, or there is sufficient evidence to prosecute any party. I would like to put it on record that we take the position that we, on behalf of the first accused, have no objection to the termination at this stage. Without prejudice to the right of the first accused to pursue her own claims against all those who have violated rights, and in particular Mr. George Kinoti and the team working under him at the DCI. In addition to that, there is at the center of this murder case a very surprising sideshow, which is the holding of the matrimonial home of the first accused as scene of crime.
Counsel, is that part of this?
Yes, I am pointing out.
That is it. As far as I can gather, there should be a case of the family division. Is that part of the criminal file we are having?
Yes, it is.
Let me not go into that, counsel. I don't want to.
Please, my lord, please hear me out.
I don't want to handle matters that are before another judge.
My lord, I'm not talking about what is before another judge.
There is a succession issue.
My lord, if you hear me out, you will, in one sentence, you'll understand what is before you.
I'm just scared of going into there because that is not my realm under the matter before me.
Please, my lord, don't be scared. Mr. Kinoti has left office.
Not Mr. Kinoti, me and my colleagues handling that matter.
My lord,
That is their realm, so let me not talk about the succession issues.
My lord, I'm not talking about the succession issue. If you hear me in one more sentence, you'll understand where I'm going. Please, with great respect, I plead with you. My lord,
and you can be sure, Mr. Mugo, that I have equally restrained myself in my notes, which I think I should just clarify. I'm not writing names of personalities in this. Mr. Kinoti, the I is called what? Gashomu. I go with the office. My notes will read the DCI or the DPP, and that's it. If there are any issues or any cases pending intended to be filed in the names of any persons, that would be another case. I am dealing with unknowingly prosecuted. That's basically what my notes are reading. I'm not writing names. I'm writing offices.
Thank you very much, my lord.
I hear you and I'm grateful. And if I may just continue.
Yes.
On that issue, to clarify that I'm not dealing with the succession matter.
Yes.
The property in question is held by the DCI as a scene of crime. Alleged scene of crime. So that is the part I'm confining myself to. The property and all its contents are held as a scene of crime. And I was going on to detail the matters which first of all, we have no objection, but we are saying these are the outstanding issues. And with regard to the property, I would want to place it on record that if the nole is accepted, the accused are discharged, and the orders vacated regarding the alleged scene of crime, I am seeking an order that the property in question be handed over to our client. And I'm not saying the ownership, that is a succession matter. I'm saying because it was taken from her under the supervision of the court with all necessary inventories taken. My lord, I say this